I would like to thank all of you for coming. Today, this is UNE Constitution Day in this campus, and I think there is another function in the Portland campus as well. So be aware of that if you want to attend the other function. The Constitution Day at UNE motivated and originated by the US Congress, especially the late Congressman Bob Byrd, who is also known for Mr. Residing Constitutional Scholar in the United States Congress, very, very strong advocate of the Constitution. And the year 2004, he, by the way, he has been serving in the Congress for a long, long time, almost all of his adult career. He noticed something that bothered him, which is American youth and American citizens not being knowledgeable or aware of the American Constitution. So he lobbied for a long time, and at the end, the fruit of his efforts led to an amendment making the Constitution Day is required for all institutions, high school and college alike, especially the one who receive federal aid. So all institutions, educational institutions in the United States who are part of this financial federal aid are required to have a Constitution Day. And which we followed suit since 2004 to do that, but also to make it a little bit more interesting, more exciting, more real than just the required bureaucratic stuff. And I hope today will be also an interesting panel, as we have done in the past. And the way we have done the Constitution Day is to organize a panel centered on one theme or two themes about the Constitution. We start with various strategies, various narrative of how to read the American Constitution. And then often we focus on one resolution, one issue, one public case that really captures the day and the time. And it's not a secret that the healthcare reform issue has been one of the most important issues recently, especially after the Supreme Court resolution. And in American society, we are still debating either for or against this resolution. And also, it's not a secret that our current presidential election is also shaped and influenced by the whole public debate about the healthcare reform. I am glad to have two colleagues with me. By the way, most of you know me. I'm an old-timer here. My name is Ali Amida. I'm also the chair of the Poli-Sci department at UNE. I have today with me two colleagues. My colleague, Professor James Roche, who has been teaching with me since the beginning of the Poli-Sci program at UNE. I thank him for enduring me, enduring my jokes and my stories. And he's currently a lecturer and a pre-law advisor for our students in political science, but also in the College of Art and Science in general. James teaches courses related to law, also public policy, and he wrote a master thesis on the politics of healthcare and insurance, if I got it right.
Yes.
So this is really his terrain, and he knows that subject quite well. Also, I'm really delighted to also have with me Professor Ron DePries, who joined UNE in the year 2006, but he has been active in Maine in public institutions and government consulting and now he is a professor at UNE with an interesting background in his degree in political science, but basically he pursued public policy, especially health issues, for a long, long time, especially in the state of Maine. And Ron is now the director of the newly formed Center of Community and Public Health. And he just told me before the start that he worked for the medical school, but right now his office in Portland in charge of directing this very important center of excellence that we have now at the university, including other centers of excellence in the various colleges and branches of the university. Ron, is an area of expertise and also experience in the public sector is related to public policy. So the two colleagues can really share with us their experiences and their knowledge and their interpretation of the resolution itself, and also the implication as a public policy for this central issue that's galvanizing the whole country and our public debate. What I would like to propose here for us is the following. First, there would be a brief introduction to the U.S. Constitution, and I think Professor Roche would be able to do that. Followed by a brief review of the resolution itself and how the Supreme Court justices came to their conclusion. And what does it mean? It's not only the resolution itself, how they came about it, how they argued for it, and what's really upheld in the whole healthcare reform, and what also being still contested or being revised. Ron, will probably will address the policy implications for the health care reform and the healthcare resolution so far. Now, as we know that the issue is going to be with us in the United States for a long time. I doubt that this healthcare, for a good reason, for symbolic reasons, for all kind of reasons, it's not going to be a marginal issue. I think it's going to be with us for many years to come. So without any further commentary, I'll ask first Professor James Roche to give us a brief introduction to the U.S. Constitution and how pertaining a little bit to today's topic, if possible.
Yes, and I'll lead right into the case. But as Ali had mentioned, Senator Byrd had actually passed this the Constitution Day, the requirement in an appropriations bill. And his concern was that so few people have any concept of what the Constitution is. And that brings up a lot of concerns, because not only can you not participate in a way that's important and effective, but it also prohibits you from really even understanding the discussion on, and this is the perfect example today. We're talking about the healthcare debate. Without having some basic concept of how this works, everything I tell you today is going to go right over your head. And so, again, so that's sort of where I'll just start off, a very quick refresher. One, I always tell people on this day, it's a very simple document in reality. A lot of people sort of just stay away from the Constitution. Like it's very detailed and difficult to read. It's about 14 pages long. It takes you about 15, 20 minutes to read through the whole thing. It'll take you years to understand it, but you have a basic work understanding just to do that. And I always tell people, that all my students this. There's 7 articles and 27 amendments. If you can just have a basic working understanding of the first 3 articles, of the 3 branches, and the first 10 amendments, and the 14th as well. So you can be the top 1% of Americans understand the U.S. Constitution, really. The other thing is I always try to clarify is because it drives me crazy. I'll hear this in the news quite a bit. Something will happen and people will throw out that's unconstitutional. And it always suggests a basic misunderstanding, because the Constitution itself, does not apply to everything. You'll hear a company will fire someone for saying something, and they'll say that, it's unconstitutional, First Amendment. And that's not true. The Constitution only applies to the federal government. well, applies to the government, state and local as well in various instances, but predominantly the federal government. Now, Justice Roberts actually in this particular case we're about to discuss very aptly points out two things. We often look at the Constitution as a restrictive document, that it restricts the federal government and what it is that they can do and cannot do. And that is accurate, but he does actually very well point out that that's the second step of two. And the first step is that the federal government gets its power from the Constitution. And the first question that always needs to be asked is, whenever the federal government acts in any way, did they have the ability to do so based on the power that was granted to them in the Constitution? If it is, and if they did, the government did have the power. The next question is, are they using that power in a way that they're not allowed to? So it's, we always seem to skip to that second step. But that first step is very important, and that's really what the case is about. The NFIB, the National Federation of International Business, versus Sebelius. Kathleen Sebelius is the Secretary of Health and Human Services, and the individual responsible for implementing the PPACA, which is the Patient Protection Affordability Care Act. For those of you unfamiliar with the act, it's a very important piece of legislation. It affects everyone here in this room. I always tell it to my students, I'm always surprised that a number of students aren't familiar with this piece of legislation. I bet a number of you are on your parents' health insurance still because of the PPACA. It will all affect your life when you graduate. You have to purchase insurance, or, according to Justice Roberts, have to pay a tax if you don't. But anyway, so it's a very important piece of legislation. And the question becomes, and there's obviously ideological divide on whether it's a good way to attack this healthcare crisis which we have, which everyone agrees we do. Mounting costs for all sorts of reasons are becoming unsustainable. Medicare is the largest socialized medicine plan on the planet, and it's arguably going to go bankrupt in 2024. So there's no question something needs to be done, but there's a great divide on how it's supposed to be dealt with. PPACA is a proposed solution to it, and it's been passed. It's been attacked, obviously, on ideological grounds, and of course, from a constitutional perspective, is the first question: did the government have the power to actually be able to pass this piece of legislation? And if you look at, like I said, if you just took a few minutes to go through the first three articles, the first article is Article 1. That deals with the legislative branch. And the legislative branch is dealt with in Article 1 because it was looked at by the framers as the most important branch there was. Okay, they'd be shocked to see how important and powerful the Supreme Court is. They'd be really surprised at how important and powerful the executive branch is. But they really wanted the power to rest in the legislative branch. That being said, they wanted the legislative branch as well to be very limited in what it is they can and cannot do. And so what they did was they actually listed out the things that the legislative branch can do. And that, of course, presupposes that anything they didn't tell them means that they can't do it. And so whenever Congress acts, you have to look at that list of enumerated powers and see if, in fact, it's something that they were given permission to do. And there's basic things, you can build army, post offices and coin monies and those types of things. Very limited sorts of powers. The big one is the Commerce Clause. Okay, that's the big power. And it's a big power because back in the 30s, there was a case called the Wickard v. Filborn case. It wasn't always a big power, but it basically says the federal government can regulate commerce, interstate commerce between the states. And that didn't really seem all that important at the time, but this particular case came up where a farmer was actually growing wheat for his own purposes in his backyard and eating it and giving it to his animals. And he got fined for growing wheat. And he said, how in the world can you say that you're regulating interstate commerce when I'm growing it in my own yard and consuming it myself? And the court said, no, there's a whole bunch of you people, and all together in an aggregate fashion are affecting interstate commerce, and therefore the Supreme Court, the legislature actually can pass a bill like that. So ever since then, the Commerce Clause has been considered tremendously expansive, to the point where a lot of people say it almost as though there is no limits on what the federal government can do. And that's sort of been a big calling card of the Commerce Clause and a big concern among constitutional scholars. So when this case came along, the PPACA, and the two provisions which it includes, specifically the individual mandate, that's the one that requires everyone to purchase health insurance, although that's technically not accurate. The individual mandate says you should buy health insurance, and if you don't, you're going to have to pay a penalty. But that question came down is that, in fact, a valid exercise of the government's Commerce Clause? And the argument on the opposite side actually, well, let me put it this way. The argument for that it does, in fact, affect commerce is this. A whole bunch of people this thing called cost sharing or free riding in the healthcare industry. And what that basically means is when people get sick, whether they have insurance or not, there are federal statutes and requirements and also state laws and requirements that require hospitals and doctors to treat them, okay? So they go, they don't have health insurance, they don't have the ability to pay, they rack up a lot of bills, they don't pay it, and what happens? The hospitals don't eat that money, they shift it over to the people who do have insurance, and their premiums go up. That's a major reason why costs are spiraling out of control. And so the idea is, yes, we can or should be able to make people purchase it because you are in fact affecting interstate commerce. Sort of sounds logical when you listen to it that way, but then what they point out on the opposite side, this is what Justice Roberts and Scalia and the rest of the conservative wing pointed out, is that if you're going to allow the government to create economic activity with its legislation by basically saying you will have to buy health insurance, and when you buy it, you've created economic activity. And then you say, therefore, the government gets to regulate the economic activity that they created. Well, then arguably there really is no end that the government can do, right? If they can make you do something that creates economic activity, and then point to the Commerce Clause and say, see, there's economic activity, we get to come in now and regulate it, that arguably would be no end in sight to what the government can and cannot do. So that became the real debate. And it really came down to, again, Justice Roberts, I think, adequately and eloquently put it, the argument forth on the side that it should not be expanded that way. Justice Ginsburg's position was this, and I'll just quickly go over it. One, that it is activity. And her argument was this. Her argument is, healthcare is different than everything else. When you probably never thought about not growing wheat, okay? But I bet you did think about not buying health insurance. You probably thought about it and you actually ran the numbers through your head and said, you know what, I can get by. If I do get sick, I have some safeguards because they're gonna have to treat me anyways. And so unlike not buying wheat that you never considered, not buying health insurance was an actual economic decision that you ran through. And that therefore, that in itself is the activity that can be regulated. Now, Scalia say, well, my goodness, if you think that way, then you can say, anything could be, his famous quote is not buying a car then is entering the non-private car market, and certainly there's a sort of a word play there that becomes more difficult. The other aspect that Justice Ginsburg would say is even if it's not activity, it should still be regulated because it's such an enormous effect on interstate commerce. I mean, 17% of our GDP goes to healthcare costs. And so this idea of not allowing the federal government to regulate a tremendous amount of interstate commerce simply because it's not this activity element seems foolish. And Justice Roberts' response is, well, if you take that approach, again, there's no limitation on what the government can or cannot regulate. Food. Everyone has to have food, and it really affects interstate commerce. Obesity. Obesity tremendously affects interstate commerce, but you don't see federal legislation telling people they can't be overweight, that they have to eat certain foods, and if you do that, you're going to open the doors to that. So that became the real difficult debate on the Commerce Clause.
Unless you are in New York City. Of course, we're trying to regulate that, right?
Regulate food all the time.
Yes, and beverages, which is an American, of course. No, I didn't mean to.
No, that's okay. That's a good point. They are trying to do it, although that is different. And actually, that's a great example because people always talk to me, why are they saying this? I'm forced to buy car insurance, I'm forced to do these other things, but you're not being forced by the federal government to do those things. The state governments are able to do those things because, as I said, this Constitution was a gift of power from the states and the people to the federal government, specifically listing out what it can do, and it specifically says everything that we didn't give you, we retained for ourselves. So it makes sense for the states to say we can do it because we never gave that to you in the first place. And so instances where the states are trying to regulate these things are completely appropriate. The last point I'll just make, I know we're going to switch over, is the that issue actually brings up to one of my final points, which is we always think of these things as it's constitutional, it's not constitutional, as though it's sort of a black and white, 2 + 2 = 4. And this is a perfect example because this is a complex case. This went through 4 circuit courts. We have 3 levels of our district, circuit, and then the Supreme. 4 circuit court, 2-2 split. Okay, went to the Supreme Court, 9 justices. Arguably, it's 4-4-1. So it really comes down to what's constitutional is what you can get 5 votes for. And oftentimes, it's tremendously difficult and subjective. And the only last thing I will say is that it actually did officially get passed and upheld, because Justice Roberts said that he will uphold it on the basis of it being a tax. And he's getting a lot of grief for that. But in fact, if you read his opinion, I think it's very well done. I think if you understand the Constitution and the arguments he's making, it makes a lot of sense. I don't want to go over my time.
Could you briefly elaborate the argument of Justice Roberts saying, he defended it by treating it as a tax issue?
Where he really gets into hot water with laypersons is there's actually what's called the AIA, the Anti-Injunction Act, which says you can't bring a lawsuit on a tax until you've paid the tax. And they do that because they don't want people, the Bush tax cuts, right? People are concerned it's supposedly going to go off the books in January. You don't want people bringing a lawsuit and say, I shouldn't have to pay that tax for a constitutional reason. And then the thing gets extended anyways, and so you just tied up the federal courts for months for something that never happened. So they make you pay the tax before you can bring it. And of course, since no one's paid this tax, the first defense was it's an AIA issue. If it's really a tax, they can't bring the case. And Justice Roberts says it's not a tax. And then he goes and finds that it is a tax for constitutional purposes. Now that sounds so inconsistent, right? Intellectually dishonest. Everyone says, oh my goodness, this guy is just simply trying to find something. But in fairness to him, there are actually different definitions of tax for the AIA compared to for constitutional purposes. Constitutional purposes, you really look at the essence, regardless of the title. You really look at the essence of it. How is it determined? Who collects it? In this case, it's the IRS, and it's based on taxable income. And in the AIA, it's more about title and labels, and of course, in that particular case, it's not. So, and he actually there are cases where it's opposite. Something was not was a tax for AIA and not a tax for constitutional purposes. So that's not, in and of itself, a legally unsound basis. The only final point I will say is this. Justice Roberts, again, gets a lot of hot water for it. It seemed like he's trying to ram this into the tax code to uphold it. He admits it's exactly what he's doing, and he should be. And why he says that is because I am required, as a Supreme Court justice, to try and find a way for this to be constitutional. This passed the House, it passed the Senate, it was signed into law by the President. I have to do everything I can in my power to uphold it. So anything that's reasonable in any form or fashion, I have to find it. And that's what the status, that's what the precedent is in the Supreme Court. So it looks like he's doing that. He is doing that, and he should be doing that.
Yes, and it's really, very, very interesting that Justice Roberts, who usually sides with the conservative wing with the Supreme Court, James, in this case, he really acted in a different way, an independent way.
He did in some ways, we can talk about that afterwards, but
he did. And I think what you are saying is very interesting because it's not only the resolution itself, the reason and the way the justices think about the resolution itself is as important. It tells us about the reference point and also the implication of the way they think about it for other resolutions. Thank you, James. And now I turn to Ron, who's gonna share with us his own comments and views about how to think about the policy implications as far as the healthcare Supreme Court resolution.
Thank you for inviting me. A couple of comments. What I like to think about it, what did Rogers do? Rogers blinked. And where does that comment come from? When Khrushchev blinked in the 1962 missile crisis. He needed to find a way, because of the implications of overturning that bill, that law. I think he blinked. He had to. He didn't want to see the havoc that may have followed because of that. And I know that's not a constitutional argument. That's a personal argument. Having watched this court in my lifetime, the changes of court, and watched the partisanship come into the court the same way the partisanship into the Congress. But this was just too big, and he just basically blinked. So I'll let it go, and I'll find a way to uphold it. He didn't do that in many other laws that they've overturned. But he did it in this case, and I think it's important he did it. Now, this also, the whole issue of health care and going to the Supreme Court, the ACA, health reform, it's got a lot to do with how we view health care in this country. Some of us view it as a right, and we've signed on to UN resolution it's a right. But we don't treat it as a right. We treat it as a commodity. It's something you buy and purchase like you buy a car. You buy health care. You're not guaranteed health care in this country. Again, even though we signed the UN resolutions that we treat healthcare as a right. If healthcare is a right, then translates into health services. Any Western, any industrialized country treats it that way, except us. We're this outlier nation with healthcare, with many other things, global warming, you name it. But the point is, we are an outlier, and we treat healthcare as a commodity that you buy and purchase. Health services you buy and purchase, you're not guaranteed that. So that's really where the conundrum comes in, and how we get involved with these issues around healthcare, whether or not we do it or don't do it as a constitutional issue or not. It's really, we haven't made up our mind as a government yet, as a country, as a population yet, what we are with healthcare. Now, the implications, I'll just go briefly because I want to leave time for questions. You know, the issue was always debated, well, whether they overturn just the mandate, or they overturn the whole law. Well, ACA is far more complicated and far more complex than any of you could understand, and even I can understand. It covers everything from access, quality of care, health workforce, how insurance companies get regulated, what they can offer. What it's not is what all the diatribe and the misinformation about. It's not a government takeover of healthcare. Never was, never will be. It actually promotes private health insurance. It promotes employer-based health insurance, which is the backbone of this country. It doesn't take over anything, in my view, as I understand it. So but had they overturned the mandate, that would have had implications because it would have affected, the thought was, if you overturn the mandate, you will take out of the picture opportunity for people to join healthcare who are healthy. The only way this works, according to the argument, is that everybody's in together, so the healthy people will pay for the unhealthy people, because at some point in their life, they'll be unhealthy. So you try to get away from adverse selection, which is what goes on in healthcare all the time. Adverse selection means you use something when you need it. You buy into it when you need it. Employee-based health insurance was, which is going down. By the way, if you heard the other day about health insurance in this country, actually the uninsurance rate is going up for the first time. Going down for the first time in decades. And that's directly attributable in part to ACA. I would argue that all day long. But the point is that employment-based insurance has been going down continually. So what we've been doing is shifting insurance to the public sector. And just a brief comment about Medicare. Medicare is the most successful government insurance program we ever had. It is based on the German system. It works. It's cheap. It is inexpensive, and it covers people. It doesn't maybe cover enough, but it's the administrative cost of Medicare is like 2 to 3%. The administrative cost of private insurance is 15 to 25%. And this is what that law also did. It restricted how much administrative cost insurance could buy. That's why people got a check in their mail. And we're supposed to get our check. I don't know where it is. I haven't seen it yet. I heard about it. But is it coming today? Andrew, thank you. So anyway, the point is that had you overturned the individual mandate, it would have affected the implication of access and bringing people into under the tent. There's other things too, but the real concern was affecting the overall law, because there are so many parts that are now going into play that it would have disrupted the healthcare system. We're talking about now, we've been working on exchanges, yes. Exchanges, states are doing exchanges, and that's really a marketplace system. It's not a takeover of anything. But there's a new agency created by ACA. It's called the CMS, the Center of Innovations, Health Innovations. And it is basically experimenting with not only with pushing quality. Medicare now is going to be paying on the basis of quality of care. Makes sense? That would have been disrupted. Medicare is also pushing to, the government is pushing to develop ACOs, accountable care organizations, which are the old concept of HMOs before the insurance company, the corporate boys took it over, which is you cover a population. That's being implemented now all over the country. So it's the way in which the workforce in promoting primary care. Yes, there's going to be disruptions in this issue, because once you bring on 30-something million people, you have enough primary care physicians and providers to take care of them. And that's the whole point. We need to put money into primary care to have people cover them. our system is so tilted towards specialty care and the high cost of specialty care. And the other thing is about cost. The ACA didn't really do much about cost, so it really wouldn't affect it that much because we basically are experimenting. We are doing ACOs. We're doing this program because the Congress wouldn't let them. The Congress vetoed anything that had to do with really cost containment in that legislation. And that was mostly on the other side of the aisle that I would sit on. And then what's interesting about ACA, and I have to tell you this because it's so fascinating. What the Congress also did, I don't know if you know, Vermont lives over, a state over. We've done a lot of work with Vermont in the health reform. They passed, and by the way, all this stuff from the ACA came as a result of states. All the experiments going on in Maine, Vermont, California, New York, Arizona, all experiments that have been going on for a long time. And those would have been disrupted if the ACA had been thrown out. But what the Congress also did in ACA is said states cannot develop a single payer system. You are not allowed to do that until the year 2017. Think of that for a minute. We're restricting states from developing a single payer healthcare system. That should be, in my view, a constitutional issue. I'm not a constitutional lawyer, so I can't. But Vermont passed a single payer system, but they can't implement it until 2017. I've probably gone on long enough. I'll give you guys to answer questions, but this is a fascinating area. ACA is very complex in the sense that it covers every area of healthcare you can imagine, from licensure issues to health workforce issues, to access issues, to quality of care issues, and some experimentation around cost. And all that's been going on in the states for a long time. It's just now being done in a more systematic way through ACA. Thank you.
Yeah. Thank you, Ron. Well, Vermont is a very peculiar state for many reasons. It's the only state that elected a socialist, a self-confessed socialist to the United States Congress. And,
so far.
Yes, and that's sacrilegious. As you know, the opponents of the healthcare reform regard this as socialism, a heresy. And that's the diversity of the United States. Some regarded this as very much a heresy. A state like Vermont in New England has no problem electing a social democrat or socialist to the United States Congress or the Senate. And that's the uniqueness and the refreshing thing about, I think, our society at this stage. The other interesting, I think, historical model that we might look at is the Great Deal, or the New Deal, that was really a turning point in the 1930s after the Great Depression, and how similar debates took place in society at that time. And America came as close as can get to a social democracy. Not fascism as in Europe, but close to a form of social democracy. And it was highly debated. And the Constitution at that time was interpreted to give another rationale to many, many measures that regarded as necessary at that time based on the Keynesian model, which is state intervention if needed in certain aspect of the economy and public sphere. Yeah, I think it's peculiar now after the similar economic crisis today. We are debating in the United States whether the role of the state, to what extent the state has sometimes to intervene, and is this really a good thing or necessary thing or not? Of course, we haven't resolved that. The final point, I think, related to this debate that has symbolic dimension, or it's a symbol. It's not just the politics, but also the symbols and the language being used to articulate different perspectives on this. The two party candidates, the President of the United States, President Obama, and his rival, the Governor Romney, is very much connected to this debate because Governor Romney, among the few governors in the United States who had some daring healthcare reform in the state of Massachusetts. And it's peculiar that the president referred to this really experience as a way to advocate and try to persuade others that this is a worthy case. It's a thorny case. Many people failed. As you know, the Clinton presidency tried to take a shot at it, and it failed for all kind of good reasons and bad reasons. And President Obama tried to do it at the beginning of his presidency. However, for all kind of politics, I think this is where my last point, Governor Romney is trying to distance himself from that experiment, and now he's trying to maybe redefine his position a little bit. Is also, in fairness to him, he's dealing with a conservative wing of the Republican Party that now in control of that party very much. So the symbolism and the language being used is really part of the politics, which always tells us that the Constitution is interpreted by human beings in a time and a place, and it's about compromises and about politics and symbols, but also, as James alluded to earlier, the justices that are appointed to the Supreme Court also determine a lot of these resolutions, and has always been the case. So the law is not a neutral, clear cut. It's interpreted by justices, lobbied by and interpreted by other courts, and politics is parts of the law as it has always been. And we're not going to be different from what happened in the past. Okay, let me stop now and open the floor for questions and comments. Yes, Tom.
I'd like to ask James and or Ron to comment on the general perspective amongst the big healthcare providers as to what they think about the Affordable Care Act. I happen to have Cigna as our healthcare provider, one of the big
Insurance companies.
healthcare providers. I happen to have a friend that's a high up in Cigna, and he's extremely angry with Obama. I'm surprised at that because, as you've noted, the Affordable Health Care Act is bringing many millions of more people into the system. It's good for insurance companies. It places no cap on spending. It's great for the insurance companies. Now, as we've talked, there is some constraints on the administrative overhead, and like that, of course. So, can you comment on that? What are the big insurance companies, health insurance companies, thinking? What's their opinion of the Affordable?
Well, let me just bring up the fact that when we passed Medicare and Medicaid in this country in the mid-'60s, the docs hated it. They lobbied against it. The hospitals lobbied against it because they saw it as an infringement upon what they were doing. And they were the biggest benefactors of Medicare, and continue to be. Without those two programs, they'd be a lot poorer, or they'd be charging us a lot more, those of us who can afford health care. I mean, there's pros and cons. I don't think. One is, yes, it's expanding the market for them. However, it's making them be more consistent, more transparent. The exchanges are all about making sure that when I read that policy and I understand that policy, it's the same language as the guy's policy next to me. And I can understand. It also restricts profits, which is a no-no because we want healthcare to be profitable, quote unquote. So it restricts them in terms. It makes them have uniform types of coverage, and they can't enter the exchange without having the proper types of coverage that we see as a good plan for people. That's part of the regulatory effects. There's a lot of regulation of health insurance companies, but also there's a lot of opportunity to expand. That's probably the two biggest things I comment on.
When they were in the room, at that point in time, Medicare was scheduled to run out in 2016. The unsustainability of the costs is not something that's going to be 8, 10, 15 years down the road, especially at the time when they were negotiating this. There was no question they were going to have to give something at this point in time. The question is how much. The public option was thrown out there. They thought that was going to be too much of a cost. Strict limitations on spending. They thought rationing. They thought that was all in the books. What they were able to work out is their best deal, and I think you can see when looking at all their options why it would be. Like you said, no caps on spending. They have to do no more pre-existing and community rating, but more customers. It definitely sustains the industry for a period of time longer than it would have been.
Doug.
I have a basic question. I have a little bit of an understanding about the idea of a person being a strict constructionist. I think that's the term. Let me just kind of blurt out what I understand to be the case, and that is that a Supreme Court justice looks at the Constitution and tries to infer what the founders meant at the time they wrote it. And that idea has never made one cent to me, because of, life goes on and our world is so different. And yet, given the benefit of the doubt, I assume that learned, serious people have a much more careful explanation of what it means to have that perspective. Could you help me
Yes.
with that?
It's often painted in the terms of being a literalist. And that's where you really get silly, right? Because how can you talk about email and these types of things? We're looking at 17, document. And Scalia is a strict constructionist in the sense. And what he would say is, clearly, I'm not a literalist, I wouldn't apply the exact words, but I can denote what the intent was in a specific area. For instance, free speech, all right? Now, granted, they didn't have email back then, they didn't have blogs, and they didn't have those various things, but from what I looked at and from my, the reading of the, talking to Alexander Hamilton and the various framers, I can get a sense of what they were trying to regulate, and I can apply those to modern day technologies. Similarly with commerce, I mean, yes, they didn't have commerce the way we have commerce, but still realizing the concerns that they had and why, in fact, they'd want federal regulation to some degree of commerce, I can apply those principles to modern day concepts, is what he would say. Does that make any sense there?
So it's built upon their inferences of a lot of other writings and understanding of those actual people.
Absolutely. They always refer back to writings. And like I said, if you look at the Constitution, it's not all that specific. I mean, you look at the right to free speech, what the heck does that mean, right? And it means, you can look at various papers from the individuals who wrote it. You can look at justices who interpreted those and base a more modern understanding of that. And you can try to, what you believe, stay true. Now, other justices, Justice Ginsburg would say that's ludicrous. Let's look at simply the spirit of the concept. That's it. I don't really need to enforce it the same way. Let's look at the spirit, and then we can apply that. And it should be a completely living document with very little limitation on what they actually intended. Just the spirit of what they intended should always be concerned about. That's the big debate between the two.
Okay, I would have a question in the back, and then we'll pull.
So one of the questions that I have, I'm fairly progressive, so God forbid if Romney is elected, but one of the questions that I have actually is this very stark talk of repealing all aspects of the PPACA. And if that is done, there are certain elements in there in the multiple pages that stipulate there will be experiments around the medical care workforce, around training for doctors, trying to expand and augment and improve the primary care workforce in this country. What will become of the obvious need for primary care physicians and providers in general should the act be repealed, based on your interpretation and experience?
Well, I think there's concern, there should be concern. However, even if Romney is elected, I don't think they'll repeal many aspects of the law. I think it's saber rattling to please the right wing of this country, and who are misinformed to begin with about what the act does. But I just can't. There's too much going on in the states on their own, which we've learned from to just dash at this point in time. There could be some key things that would go on, because don't forget, healthcare is about money. It's all about money. It's huge. The issue between the difference between when Clinton tried to make reforms back in the early '90s and now is that it's gotten bigger. The billions and billions of dollars. The Iowa just came out the other day. We waste, I forget, $107 billion last year in healthcare, something like that. I read, we waste because who gets that money? People get that money. Drug companies get that money. Equipment companies get that money. Insurance companies get that money. It pays people. So it's hard when you're in a situation where if you repeal someone wants you to repeal something because it affects their income, it affects their pocketbook, so it's very difficult. So I don't see it all going down the tubes. And I think the primary care workforce issue is so crucial that I think hopefully reason would prevail in some of those issues.
It used to drive me crazy. He would say that. And that's a blatant misrepresentation. The president can't repeal a piece of legislation that passed through Congress, signed by the previous president, and upheld by the Supreme Court. He's actually changed it. He now says, "I will begin the process of
Yeah,
repealing" in his
yeah.
later speeches,
He's
which is far more
backpedaling.
accurate.
That's right, that's right, that's right. And
What
also,
about this guy?
the narrative changes because of it's a campaign, and we know this is a big show, and you try to appeal to various groups and change your line and interpret your lines and comment on what you said before. But the fact that the Supreme Court, which is not known for being the most liberal so far, had the resolution on this, I think it makes it a little bit more complicated had it been just the presidency of Barack Obama behind this.
I just think the issue is that the Supreme Court has been probably the most activist Supreme Court that I have known in my lifetime. Striking down this, striking down that. When you talk about they try to find accommodation, it hasn't acted like that. And I would say it hasn't acted like that for a number of reasons. The quality of the justices is probably the lowest we've ever had in this country. Maybe perhaps not. In terms of the intellectual quality, look at Thomas. He's just basically an idiot, in my view. But
Well, that's
no, he's not. Well, he should never been. He never should have got that thing. They didn't let Bork go on there, thank God. But the point is that it's a very activist Supreme Court, and this time they didn't because Justice Rogers didn't allow it. He blinked.
Yeah, that's right. Well, you know, Justice Thomas is a very, very interesting, justice, and we leave it there. Paul.
Yeah, given the predictability of our politics surrounding Medicare and ACA, and the personal benefit that politicians get out of it, what do you think is the predictability of when a discussion might occur about a constitutional
Amendment
amendment
for what?
concerning healthcare?
What kind of constitutional amendment would you be thinking of?
Guaranteeing healthcare to
Oh,
American citizens?
treating health care as a right, you mean? You know, we've already signed on to the UN resolutions that say that health care is a right. I think the issue is what this country wants to, how it wants to decide how to actually do that or not do that.
The
And
only
it's very
issue with that,
complicated.
I'm sorry.
Yeah.
The only issue with that question that comes up, is it a right, is it a privilege, is the next question is, if it's a right, what is it a right to?
Right.
Unlimited, state-of-the-art, top-of-the-line, perfect health care? We can't afford it. We can't arguably even afford really good health care for everybody. So what is it a right to? Is it a right to basic health care for access to everybody, equal right, So that becomes a whole nother debate. I think the first debate on whether it's a right to anything is going to be a very difficult political debate. I think the next one is pretty much impossible in our society. So and on top of that, the difficulties of passing a constitutional amendment makes me think that's probably never, ever, ever going to happen. I feel I'd bet my mortgage on it.
You know, what Jefferson said was the pursuit of happiness. You can't be happy if you're not healthy. And so that's the basis of some of the thinking that we have that. We don't need an amendment, I'd say, to declare it a right. We need to just, because what it said, health as a right, it didn't say health care as a right. Health as a right. So we have a right. So what's that to me? To me, the government has a role in helping us be healthy. And it does. It does it all the time. Food policies. Infectious disease policies. Those are all things that protect us. Public health, to protect us. And so no one's going to argue that you have the issue about, I find the issue, well, everybody's going to demand everything. Well, the problem is that we do demand everything right now. It's why it's so costly. We demand that when we're sick and we're dying and we have diseases. We don't demand it in the front end, which would be a lot cheaper.
One last question, because it looks like some of you have to go to classes. And any other questions or comments?
I'll ask one more.
Yeah.
There was a comment made about how Medicare at the early stages was attacked as, socialistic or, un-American and all these things. Similar, Social Security, Medicare, similar kind of pattern in the early days after passage as we're seeing now with the Affordable Care Act. What's your sense of that? Do you see enough parallel there? Do you see that there's going to be a point where now everybody I mean, the percentages of people that love Social Security and Medicare is just huge, way up 80–90%. Do you see that kind of trajectory as well for the Affordable Care Act?
I do, and for a simple reason. One, it polled very well in its beginning phases, and the political process mangled it, right? It got down to below 50%. But still, when you poll people on the provisions of the PPACA, it's upwards of 85% of people love it. No pre-existing condition, I love it. Community rate, perfect. I mean, you go through all the steps, they all love every aspect of it. But I don't like the bill as a whole. I mean, there's a disconnect there. So I definitely see the trajectory, especially when it starts kicking in 2014 and people start realizing exactly what it is.
The other thing is that it's not like Medicare. It's not like Medicare. Medicare was an a state-sponsored insurance program, a government-sponsored insurance program. Medicaid, same thing. This is so much more. It's like going into a university with all kinds of programs versus a prep school with a high school degree. It's so different. So you'll see a lot of changes in parts of ACA. It's inevitable. We've got so many things changing because the healthcare system was so broke. And so it will be changed. People will like some parts of it, not like some parts of it, but that's not ACA. That's a part of ACA. So I see acceptance in the access side. The irony about the access side is that it's going to cost us some money. The irony, I just want to leave you with this, the Republicans in the Massachusetts House and Senate supported the individual mandate. The Democrats didn't want it. They didn't want it. And Romney supported that. But what Massachusetts did, unlike Maine a little bit and unlike Vermont a lot, was that Massachusetts did not put in any money into the act. They just said, we're going to expand access. And the state went into huge debt immediately because it got such, people joined the plan, joined the Commonwealth Care Plan, joined those plans. And so I find it ironic that he talks about, well, I had no deficit. Well, he did. It really created havoc in Massachusetts, but the R's really supported the mandate, and that's where they got it from. I mean, the guy who set it all up in Massachusetts went to work for Obama. Health care for all. He went to work and architect that part of the ACA. So it's kind of ironic. That's all that we forget the history of these things. That's what I do. I look at the history of these things.
Yeah, I think history is very, very important in looking back at these policies, public policies. It might also be useful as we try to sometimes raise these issues with our classes to look at other, democracies and models that exist there. And I think that will help us look at the fact that this is not an aberration, this is not unusual, even though our dominant sometimes thinking is we are leading everybody. And it might be humbling and useful to look at other societies that maybe tried some other combinations that will help us fix the cost and the execution of healthcare, which I'm sure is going to be with us for a long, long time. And for our students, this is also a real issue that's not going to die. I want to thank James and Ron, and I want to thank all of you for participating today.